topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Experts, where we bring you the finest experts in the fields of legal, health, financial, and home improvement. Today is our K. Bender Rimbaum show. They've been with us for 6 years now. We will be doing the live show for the entire hour. We're going to be with board-certified attorney Andrew Black today. If you've got a question, you can call us at 561-623-9429, and we will be here to answer your questions. Let me introduce you. He's been on our show before, attorney, board-certified Andrew Black. Hey, Andrew.
Hey there, Steve. Great to be here. Always nice to see you, and excited about what we got in store for tonight.
Listen how he butters me up. I can't believe it. Checks in the mail, Andrew.
Yeah, you got it.
So we're going to, first of all, before we go anywhere, we have got to tell people about K. Bender Rimbaum, as well as your background.
Absolutely. Well, our firm, K. Bender Rimbaum, we're a full-service community association law firm. Our primary client base is condominium associations, homeowner associations, cooperatives, country clubs, all throughout Florida. Pompano Beach is our main office, but we have offices in Palm Beach Gardens, Orlando, Tampa, Miami by appointment. And really, we're a soup to nuts firm. So any legal issue that could arise in a community association world, and as you know by now, Steve, there's a wide variety of these things that could pop up when you have people sometimes living in such close quarters and trying to follow rules. All sorts of interesting legal issues arise. We have at our firm 20 total attorneys, including 9 board certified attorneys by the Florida Bar, board certified in condominium and planned development law. We also have a board certified construction attorney. Certainly we could assist with any type of construction matters that could arise. And we're fully staffed and ready to assist any South Florida communities.
Andrew, one of the things I love about your firm is you mainly concentrate on community association law, whereas there's a lot of firms out there that might be one of the areas they work in, but they also do criminal law, personal injury law, family law. You just concentrate in basically one area.
Exactly. You know, the law has become so specialized now that we feel we can service our clients the best, where you're not paying your attorney for him or her to learn about the whatever area. With us, we do this each day. And we currently have over 1,000 clients, everything from contract review, construction defect claims, like I mentioned before, amendments, rule enforcement, collection of the owner assessments, general corporate law, fair housing matters, So really any type of legal matter that could be impacting a community.
Andrew, is it getting a little crazy now with the state of Florida's bringing in a lot of new laws when it comes to community association that are going to be starting, I believe, next year? There's a lot of new areas.
Yeah, I mean, look, since I've been practicing law, sometimes the changes to the Florida statutes, and we're talking about Chapter 718 for condominiums, Chapter 719 for cooperatives, and Chapter 720 for HOAs. Some years there's not a whole lot of legislative action. Certainly, in response to the Surfside tragedy, most of you all out there have heard or at least seen something regarding that new Senate Bill 4D. It was effective, last May. That brought lots of new changes regarding really safety and the way communities have to do what's called a milestone inspection, how they have to do what's called a structural integrity reserve study, and the way that they have to plan for these significant repairs. The state of Florida response to that horrible tragedy was they didn't want communities to really kick the can down the road anymore. They wanted to make sure that the buildings were being inspected, that the buildings were being financed properly, so there were reserve funds available. So there's lots of new legislation in Senate Bill 4D. The legislature's actually in session right now. I believe this session ends next Friday, where there may be even some more tweaks to that Senate Bill 4D. Nothing major in terms of they're not getting rid of what they just adopted last year, but some tweaks to clarify certain issues regarding the milestone inspection, regarding the structural integrity reserve study. So be on the lookout for that in the next month or so, once we get clarity on what actually will be adopted, what the final version is. Obviously, our firm will be happy to come back on your show and chat about those new changes more. And certainly we'll provide that information at our website as well, kbrlegal.com.
Andrew, with all these changes and I guess condos are going to have to bring in specialists. If you're three floors or higher, that means engineers, architects. How are people going to afford this?
Yeah, it's I wish I had a magic answer for that. I think certainly most practitioners in the field and most owners, most members of their board, most property managers, really any professionals that work in the community association world, I think most will agree the cost of owning a condominium in Florida certainly is only going to increase. We didn't even talk about the insurance costs, right? Insurance costs are, increasing. I've gotten many, somewhat panic calls from clients the last, few months when they get their insurance premium, what those increases are. And obviously, if communities had not financially planned maybe as well as they should, there's going to be a bill coming due. And it certainly is. I think we will see some communities where you do have owners perhaps living on, fixed incomes, that there are going to be some really tough fact patterns where an association might need to levy a large special assessment to fund some of these projects, to get some of these licensed professionals in. Perhaps they could explore even obtaining a loan or a line of credit. But yes, I think absolutely the cost of condominium ownership is a very real and a very significant concern that I think is going to impact us all in the next few years, certainly.
We have a comment that's what I love about the TV now. We have our comment, our chat line. What will be the requirement under SB 154 if it passes for a condominium association to waive non-structural integrity reserves?
Right. So, and I believe we know the individual asking that question. He's certainly one of the
Yes.
more well versed, and he loves the legislative process. Obviously, the Senate Bill 154. There's a House companion bill as well that's being vetted, I believe, as we speak, to see what the final version will be. Again, it's my understanding that session ends May the 5th. So time will tell as far as what the final approved version will be. My personal feeling is I don't love to speculate on exactly what the new change will be until it is final, a done deal, because we've seen lots of somewhat unique 11th hour things happening when you talk about how the sausage gets made in the legislature. So as I mentioned, sort of stay tuned. Let's see what happens when this legislative session ends as far as what the new bill will be, whether it is the new Senate Bill 154 or the House companion bill. I think it's 1395. So we'll just have to see what's the final version.
We've even had people who've called in who said, we're really not 3 floors because we have tri-levels. So our first level is the garages, and then the second, but it doesn't matter. It's if you're 3 levels or higher, you're going to have to do the inspection.
Yeah, I mean, listen, ultimately, if your local governmental agency finds otherwise, that could be something you could use as a basis. But I think 3 stories means 3 stories. So I would be cautious about not going forward with that.
But Andrew, the bottom line to all this is we don't want another Surfside.
No, listen, right, and I think taking the politics out of it, I think the state had to respond with something, right?
Yes.
And yes, Surfside, of course, was as horrible as it can be. And the goal is, of course, never to have anything like that happen again. Certainly, the actual physical issues with that property, that doesn't have anything to do with whether they had reserve funds or not, right? But I think the goal is to ensure that the maintenance and repairs aren't getting deferred and pushed, down the line so much where buildings are left scrambling to come up with funds to do repairs that they have to get done. So I think there's some very positive changes. And again, let's stay tuned and see what happens the next couple of weeks.
Well, the way we do with this show, because we get inundated with phone calls, we actually ask you to send your questions in by text, and we always get easily 25, 30, 35 questions easily. K. Bender Rembam is, without a doubt, between all 10 of our markets, is our number 1 show. It gets the most people who write in, who call in. So what we do is we read your questions on air, and Andrew will be answering those. The first one is Kelly in Boca Raton. She wants to know if a condo board updates or changes a rule or regulations for the happiness of the residents, and it's different from our bylaws, is it legal to do so since our docks are 20 years old?
Well, that's a great question. And I certainly love that the board is trying to adopt rules for the happiness of the owners. I think that's a great thing. The one thing I'll mention about rules adopted by just the board is before you put them into effect, preferably before you even vote on them at a meeting of the board, is you want to make sure that you're not adopting a rule that would conflict with what your governing documents already say. And I believe Kelly referenced that her governing documents said one thing, and the board wants to adopt a rule that goes against that. And if that's the case, that could create a fact pattern where an owner could challenge the rulemaking authority of the board by saying that you can't, just as a board, you can't adopt a rule that would conflict with what our existing recorded governing documents say. Because really, if you want to change what your existed recorded governing documents say, you would need to present an amendment to the owners, to have the owners vote on that change, not just the board deciding amongst themselves that they want to change it. Now, if the board change is for the happiness of all of the owners, then it seems like the owners may be willing to vote in favor of that. So if that issue is brought to our attention, we would likely give the advice that make sure that you don't need to get a vote of the owners before you go ahead and adopt those rules.
We just got a question in on our TV side. Are we able to deny a new resident that has a criminal record or sex offender?
Wow. Yeah. So that's a great question. I usually do my little attorney spiel, which is, this is general information, right? I don't want anyone out there to go back to their other board members and say, I got a legal opinion. We're okay to do this, right? So you obviously want to get with whoever your current association counsel is. What I will say generally is that negative criminal history could be what we call a good cause factor to turn someone down. Now, it's important. It needs to be a felony conviction. Okay, it can't just be a charge, right? Because in this country, you're innocent until you're either plead guilty or you're convicted. So you need an actual guilty conviction or a guilty plea of a felony crime. If you have that, then you also need to review how long ago that felony conviction was and what type of offense was it. If it was in relatively recent time and it is dealing with sexual crimes, certainly like against children or something like that, and you have a convicted felon, I do think that would likely be good cause that you could reject them, with the caveat that your governing documents must allow the board to even be involved in the application and approval process. I can't tell you how many times I've had to bear the unfortunate news where I've had a client come to me and say, we want to reject this person from either renting or from buying. And I review what their recorded governing documents say. And they don't even, I say the association does not even have the approval authority. So step one is confirming that your governing documents actually have approval authority there. If they do, then yes, if it is a felony conviction of relatively recent time of a serious nature, that could be good cause to reject that individual.
Let's go back to our TV questions. What is the voting requirement under SB 154 in its current version to waive non-SERS reserves?
I believe that was the same question we put on the screen earlier, I think, dealing from the our very interested legislative friend. Yeah. So we'll just have to stay tuned. Let's see what comes out of this current legislative session.
Okay, let's go to Bill in Davie. What is the difference between material alterations and architecture change?
Oh, okay. So let's start with the material alteration first, because that's actually a term that's used, and I am presuming we're talking about condominium associations governed under Chapter 718 of the Florida statutes. That's where that phrase material alteration arises. It's actually mentioned in the statute itself. And there's case law in Florida that essentially provides that a material alteration is some perceptible change of either the use, the look, or the function of the common elements. Okay, so easy fact pattern: a condominium has an old clubhouse. It doesn't get much use anymore. The board's thinking about, let's knock this clubhouse down and let's install brand new tennis courts there, right? That would be a material alteration. And the way the statute works is you may need an owner vote. So you have to confirm with what your governing documents say. If your governing documents are silent, then you need to obtain 75% approval of the owners to undertake that material alteration. So you want to think of a material alteration like a capital improvement project, some aesthetic change. A material alteration is not just repairs that have to be done, right? If there's a necessary maintenance project, something's broke, it needs to be fixed, the board always has the authority to proceed with that necessary maintenance project. The second part of that question, I believe he was asking, what's an architectural change?
Yes.
That could be a material alteration. Usually when I see the phrase architectural change, that oftentimes is dealing in your recorded governing documents about whether owners themselves need to obtain board approval to perhaps do an architectural change within the boundaries of their, within the boundaries of his or her own home.
Andrew, how's this vote taken? How do people learn about this change? Is there a meeting called?
Yeah, sure. So yes, almost always there would be what's called a special membership meeting. Notice is sent out. If your documents are silent, you need to give at least 14 days notice. Owners typically can either vote in person, they could vote by proxy. We even have some communities which have approved and have started what's called electronic voting. Not as simple as just sending a Gmail email, but you actually have a third-party electronic voting software that's password protected that owners can sign up for. And certainly electronic voting, I think, has been a huge help to make owner votes go in a much more efficient way. There's also there could be perhaps a way to vote what's called via the written consent process in lieu of an actual meeting of the owners, where if your documents allow it, if you're a condominium, the board could just send out a simple written consent form that owners could just sign off that they agree to that material alteration change.
We're going to go to our first break. Andrew, give everybody the phone number, the 800 number. It's good for all the different cities.
Absolutely. It's 800-974-0680. That's for all of our offices. And our website, again, is kbrlegal.com.
Go to the website. It's got some most interesting read on there. And we're going to go to break. When we come back, we have more with attorney Andrew Black. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We are here with the attorney, board certified. I have to say that because it is something special when you are board certified. Andrew Black, K. Bender Rembaum. We are answering your questions like we do the first Thursday of the month and the last Thursday of the month. And we have got one of the finest attorneys at the firm with board certified Andrew Black. Andrew, let's go to more questions.
Sure, let's do it.
Let's go to Kathy in Boynton Beach. Do you ever recommend borrowing funds from another reserve account to fund another reserve account project, i.e. roof funds for dock projects?
Okay, so for condominiums, the way the law stands right now, we're talking about Chapter 718 of the Florida statutes, is there's 4 reserve accounts you must have, okay? Pavement, painting, roadways, and any other item of deferred maintenance over $10,000. If you maintain what's called component reserves or just individual reserve accounts, the main takeaway is those reserve funds are restricted for that reserve project. And you're not able to borrow from one to pay for the other without getting an advance owner vote. So there is really no such thing as borrowing from reserve funds. You want to make sure that if you need to use reserve funds for what the statute calls an alternate use, that you're obtaining that owner vote first. What I'll add to that, the statute does allow condo associations to pool those individual reserves into one pooled account. And if you do maintain pooled reserves, certainly you can use those reserve funds for any item in that combined pooled account. But before you do that, you want to just confirm certainly with your financial professional, if you're unsure in the way that your reserve accounts are currently handled.
Okay, going back to our chat line, our TV chat line, the gentleman who wrote about the sex offenders, do they also have to report that to the other residents?
Well, the short answer is no. And I believe he's talking about, reporting that perhaps there's a convicted person or something. If they do approve him, there's no legal obligation that I'm aware of in Florida law that makes it an affirmative requirement for the board to somehow share that. Certainly, if the information is public information and you're certainly just providing what's out there in the public domain for anyone to see, there's no the board wouldn't be prevented from sharing that, but I'm not aware of any requirement that they're forced to share that.
I'm surprised. We used to always get letters about emotional support dogs, and for some reason we haven't gotten any in a long time, but sure enough, we've got one now. Okay. Jake in Hollywood. How do you get rid of a fake emotional support dog that are oversized, and people have several of them, and they say they need several emotional support dogs for one person.
Yeah, this
Well,
is
there's a
usually
lot
a
there.
pretty popular topic for sure. My wife and I just adopted a dog last week, so we've been up
Oh, good for
each
you.
night. We love dogs, but I totally get it. I totally get it when an owner buys into a community that perhaps has a no animal restriction. There could be frustration when there are these emotional support animals. We actually give entire uh, courses on just the emotional support animal topic. What I will say is there is language in the Florida statutes, chapter 760, I believe 0.27, was recently adopted to clarify these emotional support animal fact patterns. One of the things that this statute clarified is that an association is entitled to obtain documentation from a health professional that establishes the disability related need for that emotional support animal. And it's not enough. Sometimes owners submit these very fancy looking certificates that they get from perhaps an online site.
Yes.
And the statute makes it very clear that those certificates in and of themselves is not sufficient for a board to be forced to approve that emotional support animal. Also, I think it's important to point out that if an owner wants more than one emotional support animal, that recent statutory change allows the association to require information from that health professional that specifically identifies the need for both animals. And sometimes a health professional, they may be willing to say someone needs one. Sometimes they get a little bit apprehensive about putting their name in writing saying that someone needs more than one. Is it possible? Sure. But if you're on a board and you're dealing with a rash of these, increased emotional support animal requests, you might want to get with your association attorney to see if there's some reasonable rules you could adopt. However, you cannot adopt size restrictions. So you wouldn't be able to say, we'll allow an emotional support animal, but it has to be a certain breed or it has to be a certain size. Those types of rules would likely subject you to a possible housing discrimination claim. So you want to be certainly careful and tread lightly dealing with these emotional support animal fact patterns.
Okay, we're going to go to Matt in Dania Beach. This is a question about reserves. What about people who are not funding their reserves properly and have been raiding the reserves to offset maintenance and repair costs instead of replacements? Is that even legal?
Well, I certainly think it could subject an association to a possible complaint. We're talking about condominiums, obviously, homeowner associations, unless your documents clearly establish statutory reserves or owners have previously voted them in. Homeowner associations most often don't have any reserve requirements. So presuming we're speaking about condominiums, certainly the improper use of reserve funds is certainly that something that the state of Florida would not look to kindly toward. The way it's supposed to work is you're supposed to have a reserve study done that analyzes really what the remaining useful life is of those reserve items. So if your parking lot only has 10 remaining useful life, useful years left, you're going to have to repave your entire parking lot in 10 years. And it's going to cost $100,000 to do it. And you're fully funding reserves. You're supposed to be funding 10 grand a year, right? So at the end of the 10 years, you've got that nice $100,000 pot of fully funded reserves. Obviously, over the years, some boards have allowed owners to vote to waive funding for that particular year or to perhaps only partially fund. And if that did happen, you could be left with something less than full. But definitely, boards should not be raiding like the roadway reserve to pay for something else without getting that owner vote first.
Okay. Let's go to our chat line, our TV chat line. What are the pros and cons regarding installing an outside video cam on our dumpsters?
That's an interesting question. So there are some pros and there are some cons. I would think the pros are probably a little more obvious, right? The pros would be, I'm assuming there's been some violations, either people, not throwing their garbage away properly or, vandalism or damage or something. So certainly a pro would be cameras could serve either as a deterrent to criminal activity or just bad behavior, as well as if something does happen, you could review it after the fact and perhaps pursue enforcement. So that's the pro. Some of the cons would be you want to make sure if you do install cameras that they're maintained, operational, installed by a licensed and qualified individual. You don't want to put up fake cameras or cameras that don't work, because what could happen is if there is an adverse incident that arises and someone wants to go see that footage and it wasn't maintained, you could increase some liability exposure there. Another thing I always like to talk about when we're talking about security cameras is you want to see if you may have to get an owner vote to install them if there has not been a prior history of criminal activity there or bad actions. So you want to see if your documents may require an owner vote. And the last thing, and this is somewhat common sense, but I always like to point this out. Certainly it sounds like this question was, installed by the trash dumpsters in the common areas, and owners and guests do not have what's called a reasonable expectation of privacy in that common area. So recording them is likely fine, but you never want to have a camera that, is sort of focused in, inside someone's unit or inside someone's home, because you certainly could run the risk of an invasion of privacy claim.
Okay. Let's go to Julie in Coral Springs wants to know, what is the board's obligation to the owners when choosing and onboarding a new property management company? I guess this is we're considering hiring a new property management company.
Yeah, and what's
I think the board's obligation.
Yeah, I think this advice really goes for any vendor the board may be thinking, whether it's property management, whether it's your landscaper, whether it's your insurance agent, whether it's your law firm. You want to do your due diligence as a board. Before that contract is signed, you want to certainly get referrals of other similar communities to ascertain what their experience has been with them. For management company contracts, really for any service agreements, we think it's a prudent idea to have your attorney review the contract before it's signed. It does not matter what someone verbally promised you, right? What matters is what's on the four corners of that agreement. So you want to make sure if you're on the board that you're fully aware of the who, what, where, when, why, certainly regarding your ability to terminate that service agreement. I cannot tell you how many times I've seen service agreements where boards are locked into long-term agreements without any ability to terminate without cause. We prefer that there's a without cause language there. That way, the board, for whatever reason, the wind blows a certain way, the board decides they want to go in a different direction. We think it's a good idea to have some termination without cause language in there. As far as the board's obligation to onboard the property management and certainly to notify the owner, planning as much in advance as you can. There's always going to be hiccups in a management transition, always. Even the best management companies in Florida, it takes a little bit for them to get up and running. Certainly need to transfer the records from the prior management company, get all the owner files updated and accurate, get all their policies set up. So we do encourage owners need a little bit of understanding at first. There is a learning curve when there is a management transition, but I always think the more communication a board can provide the owners as far in advance as possible, I think that's always the right approach.
This next question is from Barbara in Boca. This is one problem you will never have with K. Bender Rimbaum. She wants to know, what can owners do if their property management company is not responding or acting upon complaints regarding non-compliance with association governing documents?
Right. So that's a good question as far as if the management company perhaps is not performing up to what the owner's expectations are. I think it's important to remember that the property manager is just an authorized agent of the association. So really the association is governed by the board. So if there's concerns with a vendor, whether it's your property management company, swimming pool maintenance company, landscaper, whoever, I think certainly you could bring those concerns to the attention of the board in a amicable way, but have documentation, have factual, this is what has happened, that you as an owner do not feel like this is the type of service that is should be happening. And more often than not, boards will respond to amicable requests to look into vendor if a vendor is not performing well. So I certainly think bringing that to the attention of your board, whether it's doing it at an open meeting of the board or just sending the board written communication.
We're going to go to our last commercial. We're talking with K. Bender Rimbaum. They're a community association law firm. We're answering your questions today. We will be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is probably one of our most popular shows. K. Bender Rimbaum. There are community association law firms here, actually throughout the state of Florida. They're in Orlando, they're in Tampa, They're in Miami. They're here in South Florida and Palm Beach County. And we are lucky enough to have board certified attorney Andrew Black, who takes time out of his busy schedule to answer your questions. And we're going to go back to our questions now. And again, Andrew, thank you so much for coming on. And I know you're going to be back again with all the markets that you now are in.
Yeah, we're super excited. We always love doing these types of things to kind of give hopefully some good education, some free, advice is never a bad thing. So I really appreciate it.
And also, you can go to your website, which is KBR Legal. Is that right?
You got it. KBRlegal.com. Absolutely. And we've got a whole calendar of events up there. We've got articles on various community association topics. So lots of fun stuff.
Okay, let's go back to Pat in Oakland Park. She said, I'm in a condo, which is part of a master association. 3 years ago, HOA 720 levied a $300,000, assessment. But to date, they haven't completed the related work due to delays. Can they hold onto the monies indefinitely?
Yeah, that sounds like a construction project that's gone haywire, certainly.
Yes.
I don't think they can hold on to the monies for forever. There needs to be some result. Obviously, if the special assessment was adopted for that reason and the reason hasn't been completed yet, I don't think the association is in any sort of legal infraction just because the project has been hampered for whatever reason. If there's a possible contractor, maybe there's some sort of breach of contract action that the association could think about exploring. But certainly owners have the right to inquire about exactly the status of the project, to get a anticipated roadmap on when things will be done. Because if the purpose of the special assessment isn't over yet, I do think you absolutely have the right to inquire when it will be done. What I will say also, and there's sort of a misconception out there, let's say there was a special assessment adopted, the project is finished, the purpose is done, and there's a little surplus funds, there's a little extra special assessment funds. The association is not required to simply return that to the owners. They don't just write them a check and say, here's the surplus funds. What typically will happen is they may use that as a credit for whatever the future regular assessment amount will be. So I just wanted to highlight that small point as well.
Well, as always, this show goes by so fast. Andrew, I'm sure will be back with us again. Andrew, for those who are listening on radio, give them the phone number again.
Sure. It's 800-974-0680. Our website is kbrlegal.com. Look forward to hearing from some of you or seeing some of you out there, and hope to be in touch soon.
Yeah, and we want to thank everybody who wrote in today on the TV, on the chat line, as well as all the people who sent us in letters with their questions. We'll be back with you again next week with more Ask the Experts. Thanks again, Andrew. Have a good weekend.
You, Steve. Great to see you.
See you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.